Welcome to the Minnesota History Center. My name is Annie Johnson. I'm the museum manager here. Last month, we opened a new traveling exhibit from the Smithsonian National Museum of American History called Righting a Wrong, Japanese Americans in World War II. After Japan attacked Pearl Harbor on December 7, 1941, and the United States entered a war in Europe and the Pacific, the nation was overcome by shock, anger, and fear, a fear exaggerated by long-standing prejudice against Asians. In response, President Franklin Roosevelt signed Executive Order 9066. This order sent 75,000 Americans of Japanese ancestry and 45,000 Japanese nationals to incarceration centers across the country. The exhibit traces the story of this incarceration and the people who survived it. Young and old lived crowded together in hastily built camps, endured poor living conditions, and were under the constant watch of military guards for 2.5 years. Meanwhile, brave Japanese Americans risked their lives serving the United States military. Some 40 years later, members of the Japanese American community led the nation to confront the wrong it had done and urged Congress to make it right. This exhibit is made possible in part by funds from the Earl and Ruth Tambara and Tom Kurohara Endowment Fund to share Japanese American history in Minnesota. We're honored to have Tom Kurohara with us as our guest today. Support for this program has also been provided by the Marnie and Conley Brooks Fund. I've had the good fortune to work with the Twin Cities chapter of the Japanese American Citizens League in developing programs in conjunction with this exhibit. One of the first names that came up in discussing potential speakers to invite to the History Center was attorney Dale Minami. I would like to invite Judge Keisha Tanabe to introduce Mr. Minami on behalf of the Twin Cities Japanese American community. Judge Tanabe is a recent appointee to the federal bankruptcy bench for the District of Minnesota. A seasoned bankruptcy attorney and trustee in Minneapolis, she has excelled in diverse forums, making partner in big law and also opening her own thriving solo practice. She represented the state of New York as a public servant in tobacco litigation, and up until her appointment, made it a priority to take on pro bono matters assisting businesses in the Twin Cities, including those recently plagued by the economic realities of the pandemic and those affected by the protests of the summer of 2020. She's the first Asian American woman on the federal bench in our state. Welcome, Judge Tanabe.
Well, it's not every day that I get to introduce one of my law superheroes. Two of my superheroes are in this room. Gail Chang-Bor, I just want to acknowledge you. Gail was the first Asian American woman to become a judge in Ramsey County. I'm the most recent Asian American woman to become a judge in Ramsey County. Without people like you, Gail, I don't know if I would be here. So thank you. And Dale, I don't know if I would have gone to law school if I didn't know about you. My grandmother was at Topaz. My entire extended family resettled in Minnesota after internment. My grandfather was here for the MIS at Fort Snelling and at Savage. When I was in school growing up, you know, Japanese American people in Minnesota didn't talk about internment all the time. I think that a lot of people just got about the business of daily life. I learned about Japanese internment in the most unremarkable way. In all of my years of schooling, before one class in law school, I had seen Japanese American internment mentioned in one paragraph in one book in all of my schooling combined. And that's with a social science major in undergrad and a master's degree, etc. I still had only seen one paragraph about this subject matter. So when I was in high school, I participated in the History Day competition. And, you know, this History Center has amazing original materials, and so many of the Nisei here in Minnesota helped me with oral histories, and I learned so much from them. One of the things that it left me feeling, though, was just, how could this happen? Why did this happen? What did anyone do about it? And I learned about things like Hirabayashi and Korematsu and Yasui, and then I learned about your work. I learned about what Neil Katyal did when he was the Solicitor General. These things made me quit my PhD and go to law school because I said, I want to know how to do stuff too. And so it's just unbelievable. I'm kind of awestruck that I'm here at this beautiful institution, that we've come from one paragraph in a tattered old history book to a beautiful traveling exhibit from my state's history center and my country's, the Smithsonian, so that it's the history of my state, the history of my country, and not just the history of my grandparents. I did want to mention that in the description that everyone received in the mail, it mentions that he received the medal from the ABA. If you're not a lawyer, you might not realize what a big deal this is. This is kind of the equivalent of like the Nobel Prize for lawyers. And you might be too modest to tell everyone that, but it's such a big deal that if there isn't anyone good enough in a given year, they don't even bother to give it out. So it's an incredible honor to be here with you. Kind of a dream come true for my baby lawyer self and my now baby judge self. And I can't wait to listen to your presentation today. Thank you so much for coming, and thank you so much to the sponsors of this program. And to Mr. Kurihara, I know you traveled to be here too, so thank you so much.
Good morning, folks. It's a pleasure to be here in Minnesota, in St. Paul. Such a beautiful, beautiful museum. In California, we have a California Historical Society, and it's this squat, inconspicuous, simply unremarkable building that sits on Market Street and is not very well known. So to come here and see this remarkable edifice and all the people that showed up on a Saturday morning, I'm just really honored. I want to thank this museum, thank Annie Johnson, thank the sponsors, Mr. Kurihara, the Smithsonian. One of my friends helped sponsor this Smithsonian traveling exhibits, Ginger Liu and her husband, Lenny N., and also Carolyn Nematsu, who also is part of JCL and helped organize this. And allowed me to talk about one of the greatest civil rights disaster in American history, the incarceration of Japanese Americans, and also about a fraud on the Supreme Court that occurred during the litigation of the original cases of Korematsu, Hirabayashi in the United States. This starts with, of course, Pearl Harbor. December 7th, 1941, when the imperial forces of Japan attacked the United States at Pearl Harbor. And as a result, President Roosevelt issued Executive Order 9066, which allowed the military commander to issue a curfew and exclusion, a banishment of 120,000 Americans of Japanese ancestry from the West Coast states. And they were taken away and ordered by Lieutenant General John L. DeWitt, who was a notorious racist. He called publicly Japs are Japs. The racial strains are undiluted. They are dangerous, no matter if they're American citizens or not. This was the man who was allowed to order the Japanese Americans away from the West Coast. And they were then housed first in assembly centers, they called them, but they were horse stalls with manure on the wall, hay on the ground. They included my parents, my family, my community, my then one-year-old brother, who was considered a danger to this country. So the elderly, the infirm, the young, it made no difference. They were housed forcibly in the horse stalls first, then they went to some of the most dismal nether reaches of this country to live in indefinite confinement in hastily constructed barracks, where it was either too hot, too cold, there was inadequate medical care, poor food, number of children died because of the poor medical care, and perhaps the greatest damage was the utter humility of being branded as a traitor, as a saboteur to the country that you loved. So they were taken away, and their crime was racial ancestry, ethnic ancestry. The justification was military necessity, which we find out many years later was a total, absolute lie. 3 men stood up to challenge these executive orders. One was, this was the 9066 order that was posted on telephone posts telling people that you have to leave the area. So these are the people who were taken away, old, young, entire families, children, living in horse stalls. Actually, I was a little late on this, so. And this is Heart Mountain. This is one of the incarceration prisons. 3 men stood up to, before I go there, I think people talk of this incarceration as an aberration, but it wasn't. It was really part of a pattern of deep-seated racism against Asians ever since Chinese first came to this country in the 1850s. And after that, they were depicted as subhuman. They were told they couldn't assimilate. Laws were passed against the Chinese. Eventually, they suffered lynchings, burning of their entire communities. Finally, with the passage of the infamous Chinese Exclusion Act in 1882. And that was followed by an Exclusion Act that was aimed at Japanese in 1924. And so it disallowed Chinese and Japanese from becoming citizens of this country. 3 men stood up to challenge. I meant to say this. To Dr. Seuss, who's a revered cartoonist, was also one of those racists, and I can't say it any kinder, who lobbied for the incarceration of Japanese Americans. And he eventually in life, later on, which was gracious, he apologized for his position, saying that he made a big mistake. But of course, his cartoons still remain on the pages of history. Those 3 men who challenged the military orders were Gordon Hirabayashi, Minya Sui, and Gordon was a grad student at University of Washington when he was in a Quaker when he was taken away. Minya Sui was a lawyer, knew his constitutional rights, deliberately flouted the curfew orders. He was arrested. And finally, Fred Korematsu, who simply felt that he was an American. So there is no reason for me to follow these orders or obey these orders. The third person was Mitsui Endo, and she didn't challenge the military orders, so I'm not going to talk about her much, but she has her own separate story. It's a very courageous story. These, including Mitsui Endo, all challenged the government's incarceration. The 3 men challenged the military orders. They were all convicted. All 3 men appealed to the United States Supreme Court. The court had a problem. The problem was there was no evidence to support the claims of the government. There was not one act of espionage or sabotage that was ever proven or arrested, a Japanese American arrested, much less convicted. There was no expert testimony in their trial courts about the danger of Japanese Americans, about the disloyalty that was claimed. In fact, there was no hard evidence for a military justification for the banishment and incarceration of these hundreds of thousands of Americans, 2/3 of whom were American citizens. They also were denied all their constitutional rights. They had no right to a trial. They had no right to an attorney, no right to notice of hearings, and they were summarily, essentially imprisoned for indefinite confinement based on mere suspicion. So because of this problem the court had, it had to accept and construct a mishmash of theories, of half-truths, of rumors, and what we find out later, outright lies to justify the military orders. Interestingly enough, most of the justices on the Supreme Court were appointed by Franklin Delano Roosevelt, the very president that these men in these Supreme Court cases were testing. So what they took as, quote, evidence is that some Japanese Americans were disloyal. We don't know how many, they said, which seems very illogical. The number of which is unascertained, they said. That the cultural traits make Japanese prone to disloyalty. And they had to distinguish the Germans and the Italians because we were at war with Germany and Italy as well. So they claimed that Japanese Americans, and I could do a litany of sending their kids to Japanese schools, worshiping a Shinto religion. It went on and on. These were sociological evidence. These were not evidence of specific disloyalty. But from that, the court ruled that we accept the military judgment that these facts could point to disloyalty on the part of Japanese Americans. There was also allegations that Japanese had engaged in espionage, committing acts of espionage. And finally, they alleged, the government alleged that there was just simply no time to separate the loyal from the disloyal, and therefore be able to imprison the correct number of people. So they accepted essentially a group guilt, racial profiling, and as a result upheld these decisions, the convictions. None of these, they didn't, no scrutiny of the claims of the government, because again, there was hardly any evidence introduced. They could not do what the judiciary is supposed to do, which is to independently inspect and scrutinize the claims of each party and make a decision. Instead, they just accepted what the government said with deference to the president. The weakness of the claims were hidden, in a sense, by grandiloquent words. And I know in PowerPoint you're not supposed to do all these word stuff, and I couldn't help it because there's so much documentation here. You know, you can show as many pictures as you want, but it doesn't tell you anything. So what the court did is just write this magniloquent argument. In fact, Korematsu starts with this sentence: all legal restrictions which curtail the civil rights of any single racial group are immediately suspect. It goes on to talk about the beauty of these rights. It's as if these beautiful phrases could hide the egregious, horrible actions they are sanctioning. And I think one of the telltale signs of the weakness of the decisions, and I'm taking them all at once, so they're slightly different, was the use of double negatives. And, those are things that your English teacher would cringe at. But what they said was, let me go back. Oh, I missed that, but what it does say, we cannot reject as unfounded the judgment of the military. We cannot say that the war-making branches did not have grounds for this danger. It's like coming home on Valentine's Day and saying, oh, honey, I cannot say I do not love you. Just is a very, very, very weak way of putting it. And it tells you the weakness internally of how they felt about this. And remarkably, in Korematsu, the government even says, this is not about race. Korematsu was not excluded from the military area because of him or his race. And I couldn't guess what other reason would be. It's too tall, too short, I don't know what, but race was the issue. And yet they tried to convince themselves to avoid it, which they did. Interesting enough, there are three vehement dissents. I didn't include Justice Roberts, not this justice, but a different Roberts. And Justice Murphy, in a scathing dissent, says that the exclusion goes over the very brink of racism, of constitutional power, and falls into the ugly abyss of racism. I dissent, therefore, from this legalization of racism. Justice Jackson who later became a prosecutor at the Nuremberg trials, states that the court for all time validated the principle of racial discrimination. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a claim of an urgent need. That quote has been quoted over and over, and they dissented. So the decision was 6-3, and these three men dissented. These decisions were criticized roundly over the years, almost universally. But the next 30 years after Japanese Americans were released from camps, they went around, just like Judge Tanabe said, to rebuild their lives. They wanted to forget this shame, this guilt, this terrible experience they suffered, and went around to look forward rather than backwards. And they didn't talk about their imprisonment. And we knew nothing about it, just like Judge Tanabe. I read a paragraph in high school and didn't learn about it more until really college and law school. But the fire in the 60s of the civil rights movement ignited the imagination of this country, including Japanese Americans, who then sought to examine or re-examine their imprisonment. The Third World Strike, which is a strike by students in San Francisco State, which demanded a relevant education, demanded that the dominant narrative where people of color play no part in the success of this country get taught in schools. Some people call it critical race theory. I call it the truth, because these histories were ignored and overlooked during the 60s, 70s, even in the present. And we were invisible supernumeraries in the history of this country until the Third World Strike then got people to start thinking, what really did happen during slavery? What happened to the Japanese Americans? And from that examination, from that fire, the redress movement was born, forged in that sense that we need to know what really happened. And that redress movement was a campaign led by Japanese Americans, but joined by people of all color who supported the idea of redress or reparations, $20,000 and an apology from Congress, as well as a civil rights fund, education fund. And it took years and years for them to gather the political support to get this campaign successful. And Congress first appointed a commission called the Commission on Wartime Relocation and Internment in Civilian. And their job was to examine the history and make appropriate recommendations. They held hearings across the country. And Nisei, second-generation Japanese Americans, rarely talked because of their shame. But they sat down in front of this panel of illustrious leaders of this country and just spoke with their heart. Many were crying. They talked about the tragedies, the losing of children, the losing of their parents, and just the humiliation and shame. And enlisted with a group of Rainbow Coalition was the 442 and the 100 Military Intelligence Service who served gracefully and with great courage during World War II, where their own parents were imprisoned in camps. And that told a great story of its own and is celebrated today because these men were the most decorated soldiers of their size in the history of World War II. In the middle of this redress movement in 1982, two strangers meet in the archives. They don't know each other. One is a Caucasian professor of law and political science who is researching a book about the original Korematsu, Hirabayashi, and Yasui cases. The other is a housewife, Aiko Yoshinaga Herzig, who is wondering why she was plucked out of Los Angeles High School and taken to prisons for no fault of her own. She became an expert researcher, and she and Peter happened to be looking for the same box of evidence, which they then agreed to collaborate on once they met. And what they found was astounding, that the government manufactured a record, a falsified record, to win these cases, Korematsu, Hirabayashi, and Yatsui, at all costs. They found out that the government lied about the claims of disloyalty, that they lied about the claims of espionage, and that they lied about the amount of time it took to separate from this disloyal from the loyal to avoid hearings. I get a call from Peter Irons, and he tells me that not only did we find evidence, documents themselves, which is why we're using these documents, of course, but he told me that they about the evidence they found. And additionally, part of the evidence was these documents from the government's own attorneys who were prosecuting these cases in the Supreme Court. And these documents are admitting that we're just telling lies to the Supreme Court. In writing, they're calling them intentional falsehoods. These documents were hidden for 40 years until Peter and Eichel unearthed them and discovered this massive fraud. And as I show here with words, 3 categories of misconduct. The first was suppressed official reports, which disputed the Japanese disloyalty. The second were disputed or suppressed reports refuting claims of espionage. And the third was an alteration of the original report that claimed, the report that was submitted to the Supreme Court that said we simply don't have enough time to separate the loyal from the disloyal. The Ringel report was the definitive report on the issue of Japanese-American loyalty. And K.D. Ringel was an Office of Naval Intelligence officer who was, for 2 years before Pearl Harbor, researching Japanese-Americans to determine, what their characteristics were like. And he discovered that they were no more disloyal than any other American, that there was no need to incarcerate them, that they could be taken care of by individual loyalty hearings. That report was suppressed from the Supreme Court, even though the Department of Justice had it. In fact, he writes in this, one of the attorneys, Edward Ennis and John Burling were ethical attorneys in the Department of Justice, and they say that this is an approximate of suppression of evidence, that we have a duty to advise the court of the Ringel report. And they also mention the term ethical obligation to the court, and yet their recommendation is ignored. The second claim was by Lieutenant General John DeWitt, who said that Japanese Americans were committing espionage by signaling from ships to shore and shore to ships to Japanese vessels off the coast of the West Coast. This report was investigated, or these claims, by the Federal Communications Commission, James Fly, and also by the Federal Bureau of Investigation, J. Edgar Hoover. They found that each one of those claims of radio transmissions was false, that Japanese Americans were not involved in this. And by the way, J. Edgar Hoover, no friend of civil rights, had also recommended that Japanese Americans not be incarcerated. His rationale was, a very smart one too. He said, look, I got files on everybody in the country, basically. We know who the disloyal are. There's about 2,000 of them that may be suspect, and we could just round them up and arrest them. So there's no reason to take them all away. When the Department of Justice attorneys found these reports, which were suppressed from the Supreme Court, they said that these statements were intentional falsehoods. That's what they called them, and said that it's highly unfair to this minority group that these claims out in a official publication go uncorrected. And they have an ethical duty to report this. And yet those memos, those reports, were not shown to the Supreme Court. The final bit of evidence was a report from General John DeWitt, which was submitted to the Supreme Court in an amicus brief, and it was submitted justify why we were taking Japanese Americans into prisons. And the report that was submitted to the Supreme Court said that we had no ready means. We didn't have time to do it. But he had written an original report, a report before the one that was submitted to the Supreme Court. And in that report, he said, you know, it's not a matter of time. It's not a matter that we have insufficient time. It's a matter that it is impossible to tell the loyal from the disloyal. This is a resurrection of the old inscrutability argument that Asians can't be understood. So there's no way we could tell whether they're disloyal or disloyal. They're loyal or disloyal. They're just too different than us. And when that original report got sent to the Department of War, they went crazy. They said, we can't say this is absolutely patently racist. And they ordered all copies to be destroyed. So all 10 copies of that original report was destroyed, and actually burned. And there's a certificate of burning by one of the officers saying, I witnessed the burning of these 10 reports. What was weird is that there was an 11th report, and Aiko Yoshinaga Herzog found this report on the desk in the archives, and in that report she noticed a subtle change, and this change was from there was insufficient time. Excuse me, I say that wrong. It's not that it was a matter of insufficient time to we had no ready means, and they changed it 180 degrees to say that it's a matter of time, and that was absolutely different than the original report. And these then came into our hands when I get a call from Peter Irons, and he asked me, can you help lead a team to overturn these men's conviction? We have evidence that a fraud was committed on the Supreme Court. And I wasn't sure whether to think that this guy was crazy or telling the truth, because, you know, I had thought about how terrible these cases were in my constitutional law class. My parents were in prison, my whole family. They just seemed wrong. And so I said, please send the evidence. And the evidence was eye-opening. It was the evidence I mentioned. He had documents to prove what the court was, what the government was saying, what lies were being told, and that the attorneys themselves were admitting that these were in fact lies. So we formed work teams, and we had to file in separate courts because of just the legal procedure, one in Seattle, one in Portland, and one in San Francisco for Fred Korematsu. And we filed sequentially because we wanted to do it in the order of the best judge we could find. The judge we got, in fact, Marilyn Hall Patel, said, so you were forum shopping, weren't you? In other words, you were, you know, chasing down the best place to bring it. I go, yep. So it wasn't illegal. So we filed in San Francisco, and we were hoping to get Marilyn Hall Patel first, and we were going to file in Seattle later if we got a bad judge in San Francisco. Well, as luck or destiny would have it, we got Marilyn Hall Patel. We were so happy we were slapping high fives in the clerk's office, and we were very undignified. But we got what we want. And the reason we filed was kind of obvious. We wanted to tell the truth to America about what happened, the real history of Japanese American incarceration. We wanted to vindicate these 3 men who courageously stood up when no one else would, and became pariahs in their own community. They were outcasts, and yet they had the courage to fight and live under that cloud of shame. We also wanted to damage the original precedent of Korematsu that said you could incarcerate an entire ethnic group, a group of people, without charges, without hearing, without due process rights, without attorneys, for an indefinite confinement. And also that precedent that we can't challenge the president during times of war. What he says, no matter if we won't even inspect it, we'll just take his word for it. That comes up, of course, in the Muslim ban later on. And finally, it was in the context of this whole redress movement, this campaign to get justice for Japanese Americans, we wanted to be able to rebut some of the opponents of redress in Congress. And the opponents were saying, well, you know, the Supreme Court has already ruled on this. Why are we relitigating this in Congress? Well, we needed a judicial declaration that what was done in the Supreme Court was both unfair, it was fraudulent, and it was achieved by illegal means. So we returned to court on November 19th, 1983. And I opened by saying, we are here today to seek a measure of justice denied to Fred Korematsu and the Japanese-American community some 40 years ago. And I went on to explain the reasons we needed a public declaration and a finding by the judge. The government just argument could be condensed into, well, let's let bygones be bygones. This was a long time ago. It wasn't a really compelling argument. But we had the leave of court to have Fred Korematsu speak. And Fred, not a lawyer, but got to stand up and say what was done to me 40 years ago when I came here in chains and handcuffs was wrong. And I'm doing this so not just for myself, but so that this will never happen again. The judge ruled from the bench. That was very unusual. And she cited the Commission on Wartime Relocation and Internment report that said that no military necessity existed to justify the exclusion, and there was no basis for the detention. And she added that the government deliberately omitted relevant evidence and provided misleading information in papers before the court, and finally that facts for military justification were unsubstantiated facts, distortions, and the representations of at least a military commander whose views were seriously infected by racism. At that point, she vacated or erased his conviction. Fred kind of didn't know what happened. He was so stunned. I told him, Fred, we won. And he looked like about 2 feet over my head and said, oh, that's good. And that's all he could do. After all these years of trying and knowing he was right, the shock of actually winning, I think, was a little bit too much for him to take. She wrote a separate paragraph at the end that's just beautiful, wise and prophetic. It's too long, too many words up there, so I couldn't play it. But someday, if you ever read that decision, you can read her words. These decisions, of course, the original ones, were the most criticized court decisions in history. They were discredited by historians, by legal commentators. And in 2013, Neil Katyal, who was the acting Solicitor General, this is the original petitioners. I'm not doing this PowerPoint very well here. Gordon on the left, Minya Sui in the center, Fred Korematsu on the right. This is the press conference we did because, again, part of our mission was not to get their convictions overturned, but to educate the American community. Fred is in the middle, Peter Irons is on the right, work team's in the back, and the guy with the hair on the left was me. This is another story I'll tell later. It's about Ed Bradley, and 60 Minutes came to interview him. And so the Solicitor General, acting Solicitor General, Neil Katyal, who's in an analysis or analyzes on MSNBC, he admitted error. And this is very unusual for the Solicitor General, the person who argues in the Supreme Court, to say that we made a mistake. We messed up, essentially. And he issued this in writing, saying that we made a mistake, we issued a fraudulent record, and finally, in over the years, as the presidents apologized, and all three men eventually received the Presidential Medal of Freedom, the highest honor a civilian could get, for their courageous stances and willingness to come back and fight again. Unfortunately, they've all passed away by now. But these days, we've seen echoes of history from Korematsu. We thought our work was done. We thought that we were finished. We impacted the Korematsu case. We got a lot of publicity, like 60 Minutes. We were able to, inform the true state of facts. But then the Persian War happens in 1990s, and in fact, Jamie Raskin, a former professor at American University, now a congressman, called the Arab Americans the Japanese of the 1990s. And then after September 11th, we see hostility and antagonism directed at Arab and Muslim Americans. Then Donald Trump gets elected president. He resuscitates or revives the idea of a mass incarceration. And here's what he says about the Muslims.
Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what the hell is going on.
One of Donald Trump's transition chiefs, Carl Higbie, this guy here, echoes what Donald Trump says on national TV. But
Sorry.
Okay.
Back a while ago, we did it during World War II with Japanese, which, call it what you will, maybe
You're
wrong,
not, you're not proposing we go back to the days of internment camps, I hope.
Okay, all right. So Donald Trump endorses that idea too. And so we're seeing an echo of history again here that is very, very disturbing because, of course, we should be learning from history. But this is in the context of a cultural war against people of color, against immigrants, and white supremacy resurfaces again.
One people, one nation, and immigration.
We're honoring the founding fathers who were white. We're honoring all of the great white men.
So in 2018, Donald Trump and the court may have reloaded the weapon Justice Jackson talks about. The Supreme Court upholds the Muslim ban, and it doesn't, without any investigation of the facts. In fact, it didn't even ask for or obtain the fundamental document, a report, why they are doing it. They just said, we're deferring to the president. That's the loaded gun that is really dangerous in these days and age. And again, these are just one skirmish in the war of white supremacy, because then next you see the idea of the replacements theory, which we're seeing this over and over again, that immigrants and people of color are replacing majority society to take over this country. You can see them march with torches in Charlottesville. We will not be replaced. We will not be replaced. It's a new battle, and not a new battle, it's a continuation of an old battle, because the rivers of racism and anti-Semitism run very deep in this country, and they tend to overflow their banks during times of crisis, during times when demagogic leaders can use that to get elected. And just a side note, Earl Warren, our famous civil rights justice, Chief Justice, was one of the main proponents of the exclusion of Japanese Americans. So the Japanese American incarceration kind of brings into focus all of these issues, the lessons about the fragility of our civil rights, that without vigilance and actions enforced through political power, the delicate balance of civil rights tends to tilt toward national security. And there's a lesson about the fragility of our institutions to protect us. We saw that during World War II, when each three branches of government failed Japanese Americans. And clearly, justice is not self-executing, and that a lesson about political power is really critical, because in 1942, nobody stood up for Japanese Americans. But in 1988, when Redress was passed, the Rainbow Coalition came together to pass the Redress Bill. It's a lesson about dissent, because in 1942, again, few people dissented against the government actions. The three men who did were vilified, and yet today they're considered heroes. I think in the end, it's a lesson about activism. If you want to create a more tolerant vision of this country, you must speak out, you must act. If you want to preserve a democracy that is threatened, you must stand up and speak out and act. And democracy is just not a given. It's not a gift. It is a challenge, and we all must fight for it. So thank you.
Thank you so much, Dale, for being here with us today and sharing your personal experiences with this important and groundbreaking history. Does anyone have questions for Dale? We have time if anyone would like to ask a question.
Thanks for coming here today, Mr. Manami. As you know, and we've talked before, I'm a Guantanamo defense attorney, still on an appellate case with Guantanamo, and having to research all of this, including the Japanese-American internment and whatnot. But I guess I'm just throwing out here, and as mentioned to you, this was all under martial law. And as the Judge Murphy pointed out, it's not martial law, it's martial rule. And these cases are still alive, as you pointed out. But we have Section 1021 of the 2012 NDAA, which provides for military detention, which went to court, and it was said Noam Chomsky, Dan Ellsberg, and Chris Hedges, they could be put into military detention for their expressive activities. Anyway, I know you stay abreast of these things. Could you talk a little bit more of maybe the expanded meaning of what all this could lead to? Trump, of course, took it up to the highest level, but the civil unrest of 2 years ago, we had people like Tom Cotton and others calling for martial law to be declared. Perhaps you could discuss that a bit, and with reference maybe to Hawaii.
Right. I think the idea of martial law is just a concept. I think what Japanese Americans suffered was the essentially martial law, where the military takes over civilian functions of the government. It's dangerous, difficult. It was imposed in Hawaii, in martial law was, and yet the Supreme Court eventually overruled Kahanamoku versus the United States, overruled the use of martial law. It's really drastic to use that governmental power, because it's pretty much absolute military power, and you're ceding the civilian government. I think what best answers that question is that it's not a matter of what you term it or what you call it or what you name it. It's a matter of the political will. And so that, what I mean by that is what Justice Scalia said many years ago when somebody asked him, do you think this could happen again, the incarceration? And he said, he uses Latin, in times of war, civil rights suffer, or the civil rights are silent, which means that people ask me this all the time, can this happen again? Well, it's again, you're not going to have an institution that can protect you against a rising flood of sentiment to imprison an entire group of people. The political will of people can overcome any type of law that you create. I hate to be so cynical about that, being a lawyer, but I've seen it happen. And so it's up to the political will of us, of people who are going to resist these types of actions that are akin to martial law, to stop it, and to stop the type of white supremacy that is occurring now, that's leading to murders in Buffalo, murders, the Jewish synagogues are being attacked, 21 Latinos in El Paso were murdered. Again, that whole rhetoric of replacement theory is now leading to just terrible results on the streets. And so all of these things are necessary for us to speak out and act on. And if it's not changing the government, it's engaging in whatever political activity you can.
I was wondering a couple of things. One was, how did they determine, and how far back did they go to determine Japanese ancestry? Was it how people looked? Was it, how many generations? How did they determine this? That's the first question.
Oh, that's a good one. I think there was a registry, and if you had I think 1/16 Japanese blood, you were considered Japanese.
The other thing I wondered was, what were the, I don't think you mentioned, the men that were convicted, what happened to them? Did they serve time?
Minyasui, who, let me start with Fred Korematsu, got probation, but he was whisked directly to the Tan Fran horse stalls where he lived. He was granted bail. They paid bail. And as soon as he tried to walk out of the courtroom, the military police took him to prison. Gordon Hirabayashi had an unusual story. He was a Quaker. He was against serving in the war, and he was sentenced to 30 days each. He had 2 counts, 30 days each, a total of 60. Instead, he said, "Judge, can I have 90 days?" It's probably the only time in history a defendant asked for more time. And the reason he did that is he learned that if he did 90 days, he'd get to stay in the outside work crew. He'd rather be outside. So he got 90 days, and that actually, and that went concurrently. In other words, both sentences were merged, and that came back to haunt him later on in the Supreme Court. It's too complicated right now to go into. But because he was against the war, he refused the selective service, and he was convicted of another crime. And he was sent to prison in Arizona, and they told him, "Gordon, you know, it's time of war. We don't have transportation. Can you hitchhike down there?" So Gordon duly hitchhiked down there, went to prison. Prisoner said, "We don't have a record of you being here. I mean, can you go into town and watch a movie or something and come back in an hour or so?" He goes, "Okay." Goes to town, watches a movie, comes back. They go, "Oh, we found your record. Now you're in prison." Min Yasui, who was a lawyer and a bombastic, wonderful speaker, went to jail, went to solitary confinement for a year. And so he had the worst sentence of all, and his decision in the Supreme Court, which he had hoped to get, simply became an adjunct of Hirabayashi. So Hirabayashi's case does a long analysis of the cultural characteristics, etc., and his conviction is upheld. And then the case right after that is Min Yasui, the lawyer who wanted to do a test case, and essentially the court just says ditto. I mean, he doesn't get any kind of great result from that, and yet he has to spend a year in jail. He became a civil rights leader in Colorado, and for a multicultural civil rights leader who's supported many, many causes. He was a wonderful man.
Thank you. I thought I've read that there's an effort to get the current Supreme Court.
There's the what?
An effort to get the current Supreme Court to disavow the original decision. Is there such an effort? And given what you said a couple of minutes ago, would it matter?
Yeah, we had tried to do that right after the cases were over, and we were too tired and too poor because we did this all for free, and to get the Supreme Court to do this. At one point, we wrote to Donald Verrilli, who was a Solicitor General at the time, and asked him to get the court, and he was interested in doing something like that, overturn the Korematsu case. But the court can't do that unless you have a similar case. And that's where Trump versus Hawaii came in. And we filed an amicus brief in that case to try to get them to do it. So, but the court, what the court did in that case was really interesting, because Justice Sotomayor dissented and wrote an amazing dissent criticizing the Korematsu case, the failure to analyze the facts, the failure to resist the president's decision, and then Justice Roberts, who then wrote the majority opinion, in almost a semi-sarcastic way says, not this part of it, but later, Korematsu was wrong the day it was decided. Korematsu does not sits in our history book as a lesson, but it's overruled in the court of history. So Roberts disingenuously doesn't overrule Korematsu as a court. He just says in the side note that, yeah, it's overruled, that's bad law, we'll never do that again, kind of thing. So in a sense, the words itself suggest that it's being overruled. And yet, what you see today is that draft opinion by Alito on the abortion laws, on Roe versus Wade, cites Korematsu to say that, we've to suggest that Korematsu and Dred Scott were wrong the day they were decided, and so was Roe versus Wade. Now, whether that comes out in the final opinion, we don't know, but Korematsu is being perverted for other people's means, and to claim that it has validity in some circles. So the short answer is no, it's not been completely overruled, but it's been so discredited in some ways that you wouldn't use it to justify for example, the imprisonment of an entire group without due process. Although, like Justice Scalia says, anything could happen in politics.
Thank you so much for being here, Mr. Manami. This is such a great opportunity. I have two questions. One is, could you explain what coram nobis means in the context here? And then also you were going to say something about the 60-minute interview that I'm really curious about what you were going to say.
Well, the coram nobis, I mean, when Peter Irons suggested this, we had to go to the law dictionary to figure out what he meant, because we had never heard about it. In fact, the clerk of the court didn't hear about it when we filed our petition. It stands for before us, and it's really an old British writ where you could bring a case when your conviction was obtained through manifest injustice after your sentence was served. It's a very narrow type of a writ that you could bring to overturn your criminal conviction under very limited circumstances, and we had happened to fit right in those circumstances. So it means before us. Its corollary is coram vobis, but that's another Latin stuff that we don't need to know about. The 60 Minutes one was, I just put that in there for fun when I had more time, but in brief, Korematsu did not want publicity. He was very private. He said, look, I'll do this, but I don't want to talk to the press at all. And we said, of course not, Fred. We're going to protect your privacy. And of course we did not, because we knew we needed him. His case was the most significant, in some ways, of the three cases. And in order for us to do the education, we needed a live body there. We needed the person who was bringing the action. So we embarked on this, I think, pretty sneaky strategy. We had him do, Fred, an interview with our friend. He's a Japanese-American guy. He'll be very sympathetic. Fred did this short interview. Second time, another interview. He does a little longer interview. We're getting him used to the idea. And then after a while, we get 60 Minutes to get interested. And Ed Bradley up there is interested in interviewing Fred, because now the redress movement is gaining steam. So Fred's case becomes really important. And so they shot that in my house, and they took breaks. And at the time, we had purchased this game called Space Invaders, one of the first video games. And we got Ed Bradley really excited about it. So he and his producer, they were just madly playing Space Invaders during the breaks. But he did a very, very sympathetic and wonderful story about Fred and the incarceration of Japanese Americans. So that's the 60 Minutes story. And when they shut behind the cameras, I remember talking to Catherine, and she says to me, Fred is doing the interview. And she said, I thought you told me we were not going to be doing, interviews. There's 60 Minutes, national TV there. And I said, Catherine, I have to admit I lied. And she goes, I thought so. She was really sharp. So that's how that happened.
Let's thank Dale again for coming up to speak to us today.